Hello, everybody. You have tuned in to Eric Jose on Making a Murderer on YouTube. I cover virtually any aspect of making a murderer. I go over the evidence, the documents, the photos. So if you like, stay tuned, and in the future I'll have many more videos besides the one you're about to see. Hello, folks. We're here today to do a bit of a little update. Zellner filed today her motion to have Judge Sukowitz, the judge that denied Stephen Avery a new trial. Well, she issued her motion today asking Judge Sukowitz to vacate that order in light of the fact that there was a plan already in agreement with the prosecution to do more scientific testing, to make amendments to the motion, and other things like that she honestly didn't expect the judge Sukowitz to make the decision so quickly before she would have a chance to let the court know that she was amending the motion and there was going to be further testing, which was agreed by both sides. So I'm going to go ahead and show you here the motion, because the motion is basically her laying out the things that they plan to test and that have been agreed with the prosecution and the Attorney General's office. So we'll go into that right now, and we'll come on back. Alright, so here she's just basically been saying that her and the state agreed to do some further testing, and that testing was the RAV4 would be made available to the defendant's experts, Drs. Carl Reich and Christopher Palahniuk, for examination at the Calumet County Sheriff's Department for additional items to test, and for collection of swabs from the A. Battery cables, swabs previously collected and designated WSCL items IE and IF. B. Swabbing the bar under the driver's seat. C. Swabbing the hood crutch. D. Swabbing the interior hood release. And E. A complete examination of the interior and exterior of the RAV4 for additional forensic evidence. The prosecutors stated that they would schedule the examination of the RAV4 testing in a very near future before the weather worsened. The prosecutors also agreed that the defendant would be allowed to attempt testing of the license plates for DNA. The prosecutors also agreed that the defendant would be allowed to test the lug wrench. The prosecutors agreed that Drs. Stephen Symes and Leslie Eisenberg would be able to do a microscopic examination of the pelvic bones that were located on the Manitowoc gravel pit, which is over on the Redant property, which is interesting because Leslie Eisenberg determined those didn't belong to Teresa, yet they had the same exact calcination. Anyway, the prosecutors and the defense counsels also agreed that to streamline the litigation, defendant would amend the petition. It was generally agreed that as to what claims would be added and removed from the petition. Additionally, prosecutors and defense counsels agreed that if an evidentiary hearing was necessary to resolve the issues in the amended petition, the evidentiary hearing could last 4 weeks or more. Scheduling was discussed, and prosecutors and defense counsels agreed that the evidentiary hearing could be started in the spring and could proceed during the summer to completion. Defense counsel agreed to remove the issue of ethical violations perpetrated by prosecutor Kenneth Kratz. Defense counsel also agreed to remove the references to brain fingerprinting tests of Stephen Avery performed by Dr. Lawrence Farwell. Defendant intended to inform the court that an amended motion would be filed so that the dates for a rescheduling conference for an evidentiary hearing, if needed, could be set. Defendant did not anticipate the court filing its order prior to the time the defendant could notify the court of the matters set forth herein. On October 6th of 2017, defense counsel spoke with the prosecutors and informed them that this motion would be filed today to vacate the order. The motion was presented and and reviewed by the prosecutors, and the prosecutors agree to the factual accuracy of the representations regarding the content of the September 18th, 2017 meeting made in this motion. The prosecutors stated that they could not join in the motion. Defense counsel submits that justice and finality require that the proposed testing go forward. Defense counsel submits that the order of October 3rd, 2017 should be vacated so that the agreed upon testing can take place. So that's about it, folks. She's basically just letting the judge know that there was more. She didn't expect her decision to come so quickly, but there was more that was being agreed upon between her and the state. So, all right, so we'll move on from that, but that's basically what was in that motion. I thought you guys might find it interesting, all the stuff that she plans to test that's been agreed upon. So, the fact of the matter is that nothing ever comes easy when it comes to wrongful convictions. They are just the nature of the beast when it comes to wrongful convictions, is that they require patience, time, a lot of hard work and effort to find what you need to make your points in court, and it takes a long time, and that's just the way it is. Zellner is obviously letting people know that here, but winning means you're willing to go longer, work harder, and give more than everybody else, because everybody else wants to go home, but you're there working and making sure that you get that extra mile done, and that's what it takes. So, just wanted to go ahead and end on that note with everybody. Zellner is on top of this and doing what she can, and explaining that there was a very clear agreement existing between her and the state, and that she would like the judge to vacate the order so that agreement could be executed, and that evidence could be tested, and that the petition could be amended. So that's about it for today, people. If you haven't already, please hit subscribe, and we'll see you later.